Fourth Amendment protects the right to be free from, quote, unreasonable searches and seizures, unquote. It was written in the late 18th century when the tools used by law enforcement to investigate crime and monitor suspects were radically different than they are today. In your view, how should a judge approach interpreting and applying constitutional provisions like the Fourth Amendment in cases where the technologies or methods at issue were obviously not even imagined by the founders?
May I offer an example, Senator? I think might be helpful.
Sure.
I take United States versus Jones, a recent case from the United States Supreme Court involving whether police officers might attach a GPS tracking device to a car. Modern technology. How do you apply the original Constitution written 200 years ago to that? And the court went back and looked at the law 200 years ago. And one of the things it found was that attaching something to someone else's property is a trespass to chattels at common law and would be considered a search. And the court held that if that's a trespass to chattels and a search 200 years ago, it has to be today, though the technology is obviously different. So the technology changes, but the principles don't. And it can't be the case that the United States Constitution is any less protective of the people's liberties today than it was the day it was drafted.